It was His Excellency Gachagua's position that His Excellency Kindiki was disqualified under Chapter 6 due to gross human rights violation, including abductions, extrajudicial killings during the Finance Bill protest when he served as Interior Cabinet Secretary. Finally, His Excellency Gachagua averred that His Excellency Kindiki was not a member of the UDA party for the requisite 3 months preceding his nomination, and it was his case that the National Assembly unconstitutionally metamorphosed the process into an election rather than an approval under Article 149, Sub-Article 1. For these reasons, His Excellency Gachagua sought the following reliefs: a declaration that the respondents have contravened the provisions of Articles 10 and 18, Sub-Article 1, Articles 10 and Article 118, Sub-Article 1 of the Constitution by initiating a process leading to the removal from office by impeachment against the petitioner without first putting in place adequate legislative and procedural measures for effective public participation. In particular, the Senate's decision was not informed by any input from public engagement. 2, a declaration do issue that the impeachment motion lacks the particularization and specificity required under Articles 145, Sub-Article 1 of the Constitution and Standing Order 64(1)A of the Standing Orders of the National Assembly, and is thus incapable of invoking the jurisdiction of both the National Assembly and the Senate under Articles 145 and Article 150. 3, a declaration that the resolution passed on 18th of October 2024 by the National Assembly purporting to impeach the petitioner pursuant to the provisions of Articles 145 and 150 and the communication dated 8th of October 2024 by the Clerk of the National Assembly to the Clerk of the Senate titled, in quote, Resolution of the National Assembly on a special motion on the removal from office by impeachment of His Excellency Gachagua, Deputy President of the Republic of Kenya, close quote, are both founded on a process that is inconsistent and in violation of the Constitution of Kenya and are thus both void and invalid. 4th, a declaration that for the purposes of impeachment of the President or Deputy President of the Republic of Kenya, adequate public participation must be undertaken in all the 290 electoral constituencies in Kenya, the diaspora constituency, and the 1,450 electoral wards where the presidential election takes place. 5th, he sought a declaration that the period of 12 days provided under Standing Orders number 64, sub-order 2 and 6 of the Standing Orders of the National Assembly is grossly insufficient time for the National Assembly to facilitate any meaningful and reasonable public participation during the process of impeachment of the President or Deputy President of the Republic of Kenya. Thus, the standing order is unconstitutional insofar as it has the effect of abridging the time for public participation. 6, he sought a declaration that the proceedings before whole house plenary of the Senate of Kenya under Article 145 of the Constitution of Kenya are not limited or time-bound to 10 days, as would be if a special committee is appointed under Article 145, Sub-Article 4A. He also sought in 7th prayer a declaration that the petitioner's right to fair administrative action under Article 47, right to fair hearing under Article 50, Sub-Article 1 of the Constitution were violated on account of the petitioner being denied an adjournment occasioned by illness, thus violating his right to appear in person before the Senate of Kenya to be heard and present his case. He also sought a declaration that the National Assembly and the Senate, in their evaluation of the impeachment proceedings before them, failed to properly assess each of the specified grounds and determine if they collectively or individually constitute a gross violation of the Constitution, warranting voting to uphold the impeachment charges against the petitioner. Hence, the resolution of 8th of October 2024 in the National Assembly and the vote upholding the impeachment charges that of the Senate passed on 17th of October 2024 do not meet the threshold for impeachment set out under Article 150 as read with Article 145 of the Constitution. Hence, the same be and are hereby set aside. An order